away from the 3-yard line, and that contract was withdrawn at this point, and we are where we are. So I think that those are some pieces of information that didn't come out. I also think that much of the commentary tonight assumes that the board and we all don't know about where we are and how these negotiations are going. I think as an organization, we are where we are, and we know where we are. So we have made good faith efforts, 22 versions of contracts. Almost every one of them improved the contract in his favor. We couldn't get to closure. And this is where nothing more than a contract impasse, and I'm not convinced that we are at the 3-yard line, frankly.
Let me make a couple comments, and I appreciate everyone being here today. When I got appointed by Governor Scott in September 2011, this subpoena from the OIG was already present, and I've kind of absorbed it as a lawyer on the board and have worked closely on the issue. And unfortunately, I can't comment on it, but I would rest my reputation on it that it's a serious matter. With that being said, if I can make a recommendation and sort of play King Solomon in between, is that we as a board can't get involved in the intricacies of the negotiations. One, we're not competent to do it. We're lay board members, and our job is oversight and compliance. And I think this board, we've made multiple changes to our compliance program for positive, as that's the future of healthcare that's been directed to us. With that said, I would make a recommendation that management and the board, management and Senator Lemieux and Dr. Chizner, within 7 days meet. I have an attorney that I spoke with. I think both parties can agree to mediate it. If that would, I spoke with Ed Piswally, who's president and CEO of Trip Scott. He does represent us, so there would have to be a waiver, but I'd ask management to direct management to go and sit with Dr. Chizner and his counsel and try to hammer out a deal. So this is the finish line. Unfortunately, we're faced with tough decisions. We can't deviate from where we are. With that said, we don't want to jeopardize the health care we provide to the community. Dr. Chizner's my mom's doctor. He's a great physician. I'm happy, I think as a board, we're all happy to keep him here, but there's hard decisions we need to make. And it's hard to say that, but that's really the reality where we are. So I think this board, and I'll open up for comments, should entertain a motion to direct management as well as Dr. Chizner's counsel within the next 7 days to set a day aside or whatever time is needed and come back with a legally compliant contract, if possible. Not directing you to do it, but legally compliant contract if possible, and to meet and see if we can hash it out. If we can't, we'll bring it back to the board and we'll deal with it accordingly.
Mr. Chair, just so I'm clear, so we're bringing in additional legal counsel now?
No, what I would like is I believe that Mr. Piswally is respected by Mr. Gorn and Mr. Nass, Mr. Lemieux, and Dr. Chizner. I would like for him to mediate the dispute and see if that's acceptable with you, George.
It is.
Okay. To mediate the dispute and come back, if possible, with a legally compliant contract. By no means am I suggesting that compensation be increased, because that's not what I'm saying. What I'm saying is I'm sending you to sit down as the board. I'm asking the board to do is sit down and try to work out a deal. If we can't, and if we can't come up with a compliant contract, then we'll have to enforce the termination, and we will. But we should try at least one last time, see if we can get a deal done. That's going to be my recommendation.
Just one more time, because as you well know, I'm the slowest board member here. I'm picking up, okay? Ed Pasquale will be the mediator between Mr. Gorn, Mr. Nass, and Senator Lemieux. Is that what I'm understanding?
Meaning he has no authority other than to, and I say that only because I'm an attorney by trade. He's just, so what I'm saying is no different than any other pre-suit litigation. That he sits down, has no authority to do anything but to speak to the parties and see if he can get them to communicate again and see if he can come up with a resolution that's both acceptable to the district as well as acceptable to Dr. Chizner.
Yeah.
Let me just comment. You know, we're talking about that. We've heard at least 30, 40, or 50 testimonies about Dr. Chizner being their doctor and all. Dr. Chizner is my doctor. Dr. Chizner has done stints like myself. He's my two brothers' doctor. He's my two son-in-law's doctor. And I've known Michael since, I think, joining the Broward Health Yacht Club many, many years ago. So this is a very, very tough position that I'm in this particular matter. But I've read the information in reference to the federal government's interest in our how we run this house, and I can't ignore that. You just can't. I can't do that. You know, it's one of those things. You don't want to read the next chapter if we continue down this road. But what I've heard is George and you has indicated that it's not a money issue. That we're not talking about money, which to me means if we come back, the dollars are the same. They multiply out to be the same. It's just that they massaging as to how they are generated. That's what and again, within the framework that they worry about where we're generating. You know, we've heard a lot of information as to how the federal government, we now all can put numbers on the paper, and the federal government is very keen on making sure we move along. So I would support your suggestion. Again, I want to come back and say, well, just a few more dollars here, because that's not what I heard.
Okay. Anyone else?
Well, my question is, with some of the issues in the template, every other doctor has signed off on them. We had Dr. Chizner and another doctor out there. So, you know, it's very close to the cliff, more than the 3-yard line. I just don't know how.
You like it?
I just don't know how 22 contracts, and I hear now that it's not about money, but I understood that was something that was a big consideration. And the other thing is, the other doctors have signed off to this thing, and what's going to happen now?
I don't think, I'm not suggesting, and to comment on that if I may, I'm not suggesting we deviate from our policies and procedures. I think we're just directing them to go meet, because I think it's been contentious. And if they can't, if we can't come up with a contract within our policies and procedures, we stay where we are. If we can, then we can't do it as a collegial body here, sit here and go line by line. That's not our duties and what we're accustomed to do. So I'm only just directing that to keep a conversation going and have management report back. I used Ed only because Mr. Biswaldy, because he had volunteered that to me earlier today, discussing some issues with him. So
3 things.
sure.
First, 7 calendars. Is that 7 calendar days or 7 working days?
But what's a week from today?
So calendar days.
Right.
Okay. Just for everyone else's benefit, don't get the misperception that today is a hard decision. But a hard decision was also made back in June, when most of you in here now weren't there then. Mr. Gorin can probably help clarify for me a little bit better, but the board unanimously, for the most part, had made a decision that we would force it upon the management staff to go back and negotiate. That was done back in June. In fact, I remember writing a statement about my personal feeling was up to that point that a mediocre job had been done with negotiation. So the hard decision was made back in June. I just wanted to clear that up for the record. That was the third thing that I can't remember right now, but I know it was calendar days. All right, thank you, Mr. Chairman.
Any further comments? If the board supports my recommendation, can I entertain a motion to that effect? I think we need 2 motions. One would be we accept it, and then we would agree to waive the conflict of interest for
Just to clarify for the record, the Tripscott firm is currently engaged by Broward Health on a monthly basis. They are on retainer, and they perform services not just for the general counsel's office, but also for other matters affecting the district. So from the standpoint of Ed's engagement, I would suggest you just, as you have, disclose the issue on the record, and certainly his credentials and background are exemplary. And to whatever extent this board takes action to do what your motion would include, I certainly would not object to Mr. Pasquale as highly qualified counsel. But you bear in mind the ethical issue of disclosure, which I'm offering for Ed today.
Right, and I recognize that as well. So, if the board supports that, I entertain a motion.
Oh, hold on, wasn't one of the speakers that was here earlier a negotiation lawyer? I can't remember the name of the person. Are they still here? Oh, it's real estate though only? All right, disregard.
I was under the impression the board couldn't take any action on this matter.
Could not?
Well,
Where do we stand on the building insurance policy?
you're asking three different questions. Let me try with the first one, if I can first. I opened my conversation with the board today by telling you that there's no proposition or item on today's agenda relating to this item, number one. So there's no agenda item referencing Dr. Chizner as an item. The second issue is that you're under public discussion, which I also clarified some time ago, referencing allowing people to be heard on any topic that they so chose, so long as they weren't disruptive to your public meeting or your public business. Having said that, it'd be the wish of this commission to adopt a motion, a point of guidance to the administration and to council and to any other affected party in this discussion to take some level of action. Certainly your prerogative is to make such a motion. But you raise an interesting point about interference. I said earlier during my opening commentary as well that you're policymakers and you set policy, you set the fair market value policy, you did all the things that you needed to do in your good faith effort to respond to the federal government's current inquiry, which is still pending, as you know. It's a very serious matter, as the chair mentioned. It's as serious as they come in the context of implication on your fiduciary obligation, not just yours, but everyone's. I can't determine on the record today whether it's interference or not interference. You can ask the administration to perform the task, and you can ask the administration to perform the function of negotiating, which is what you did in June when you adopted the template and the matrix. So if that is not inconsistent with what you believe you did in June, you are the arbiters of your own activities. You get to rule on such issues of that type. Just as Congress and Washington gets to decide the behavior of its colleagues, whether it would censure one or not, or would call someone on the carpet for actions or not, you get to make that decision as to what is interference. You have, however, a coordinated effort with your administration, which does have perhaps concerns about interference and intervention at this particular time. That's the best I can answer.
So my motion can be considered interference?
I didn't say that it would.
I mean, I want to be cautious. That's what I say. If it is, I'll withdraw.
Well, that's what I'm understanding is as long as it's in the spirit of law and the train of thought we had in June, then it's not interference.
Understood. That's one aspect. I must resubmit for the record, and let's be very clear about this. And if need be, we can go back to the beginning, but which is a long time ago at this point. There is not an intent to terminate a contract, but a termination notice is out the door. That was sent and signed by the administration, as you know, on November the 4th. So bearing in mind that you're dealing with reviving a contract that's already been, the only contract that you have to deal with is the current contract with Dr. Chizner, which expires on December 31 of 2016. The otherwise given contract offer that was provided, which had multiple provisions, was removed from the table. It's no longer there. So,
Okay.